The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 24th of February, 2016 are currently trading with gold at $1,238.20 an ounce, silver $15.28 an ounce, Texas crude $31.87 a barrel, and Bitcoin is currently sitting at about 423 U.S. currency. Today in history, the year 303, the great persecution of Christians in the Roman Empire signed an edict by Emperor Diocletian, in effect stripping the legal rights of Christians and demanding that they comply with the traditional Roman religious practices of the day. In recent news, the State Stop Criminal Court dismissed criminal charges against Rick Perry for his 2003 threat to veto state funds to the Travis County prosecutors. The charge itself, it was ruled 6-2, violated the Texas Constitution's separation of power provision by limiting the governor's veto authority. Presiding Judge Sharon Keller stated that the governor's power to exercise a veto may not be circumscribed by the legislature, the courts, or the district attorneys. When the only act that is being prosecuted is the veto, then the prosecution itself violates the separation of powers. The court has also dropped a secondary felony charge of coercion of a public official as a violation of free speech right. The International Monetary Fund stated today that the global economy is highly vulnerable to adverse shocks and is calling on the United States and other major governments to prepare contingency plans that could be used to stimulate and boost growth. IMF is strongly suggesting that the world's 20 largest economies should keep pursuing strategies for growth, though they did suggest that they should develop additional measures that could be implemented immediately if economic growth continues to slump. With the IMF suggesting governmental spending as a means of stimulus, it's hard to take the Treasury Secretary Jacob Lewis's statement serious when he stated that it's not the job of the finance ministers and central banks and governors to accelerate a crisis. It's their job to avoid one. Yeah, sure. MasterCard has announced plans to introduce Selfie Pay to more than a dozen countries, a program that is part of MasterCard's plan to implement biometrics as a form of security authentication. The idea is simple. Users will take selfies through their app, and the image will be stored into a company server. Every time anyone will want to make an online purchase with their credit or debit card, they will be prompted to look into the phone's camera so that the image can be digitally matched and compared against the selfie on file, effectively changing the selfie for the traditional password. This was your lowdown for February 24th, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad trees.
Howdy, Randy Kelton, Rule of Law Radio, on this Friday, the 26th day of February 2015. Now, we'll have the call-in lines open all night. Our call-in number is 512-646-1984. Give us a call. I said any subject, but any subject that the type of which we tend to cover. Now, I'm going to start out going back to some of the things I was talking about last week about how to write legal documents. Last week, I went over primarily the concept of flow. And in thinking of a document from the perspective of how you affect the mind of your reader, it essentially dictates a method of creating documents that, for the most part, is the method that most people who teach this kind of thing suggest that you create documents, in that you don't start with the introduction. You start with writing the order, and then from the order you write the prayer, or the heretofore, as Jeff Sedgwick calls it. You ask the court for what you want, but you do that early on. You do that essentially first. This lays the groundwork or the structure for the rest of the document. A lot of times when we look at pro se pleadings, they are not clear and to the point. They tend to ramble, and they argue one issue, and as they're arguing that issue, they drift into another issue and then drift into another issue, and then they realize where they're at and come back, and they drift around again. It gets really hard for a third party, someone else other than the writer, to understand what they're trying to communicate. If you create your closing first, you start at the end first, then you tend not to have those kinds of problems. And you always keep your document moving from the front to the back in a predictable order. When you write things from the back to the front, you start out by writing by the reader. When he reads it, he starts out by reading an introduction. And when you write the introduction, you've already written the document. So now you know what's going to be in the document. If you do it the other way around, you're really not sure. Oftentimes documents kind of develop themselves. And if you start out with an introduction, you're actually telling the reader what you intend to put in the document. It doesn't necessarily mean that's what's going to wind up in it. But if you've already written the prayer, the conclusion, the statement of the factual accusation or the points and authorities, and the statement of facts, then you know exactly what's going to be in there, and you know exactly what order it's going to come in. So you tell the reader basically what's going to be in there and the order it's going to be in. This creates an expectation in the mind of the reader. The reader will expect to find your issues and arguments in the order that you stated in your introduction. So you give your reader a set of expectations, a roadmap, and then you begin to follow that roadmap. And the reader will expect you to move from one subject to another, and when you move exactly the way the reader expects you to, that establishes a thing we call rapport. So the reader connects better with your writing. Okay, I didn't want to go into a lot on that today, just kind of a brief overview. Then we get to the document styling. And most people these days use Microsoft Word or something very similar, OpenOffice, Libre. For a while there, back in the 90s and late 80s, early during the 90s, as these softwares were developing, WordPerfect was the rule of thumb for lawyers. WordPerfect is more lawyer-friendly than Microsoft Word, but because of Microsoft's marketing strategies, they've pretty well taken over the industry. So last week I went over some styling conventions. And one convention, if you're creating a document, especially a long, complex document, is put a heading on every paragraph. And you can use the styles that are already written into Microsoft Word, and every word processing software has a set of styles. And included in those styles are a set of heading styles. If you use the heading styles, and you'll find heading styles in Microsoft Word if you click the Home tab on the very top ribbon. Then on the second ribbon below that, over to the right-hand side of the page, you'll see a wide box. The bottom of that box is titled Styles. If you go to the bottom right-hand corner of that box, there's a down arrow you can click, and it'll open up a styles page for whatever document you're in. And you can scroll up and down it and find your heading styles. Put a heading on every paragraph. If you use the styles menu to do it, then you can go to, in Word, you can go to View. I can get Word to come up. Okay. If you go to View, and when you click View on the very top ribbon, then in the second ribbon, the second box over, there's a box that says ruler, guidelines, navigation pane. Now I'm looking at Microsoft Office 2010. Sometimes it's slightly different in 20.07. And 2013, I'm not sure what 2013 looks like, but it'll be very similar. What I want to look at is navigation pane. When you use the styles menu, then Word will create what looks like a table of contents. You click to open the navigation pane, and it will give you a listing of all the headings that are hyperlinked inside the document. So if you've got a 50-page document and you've got it headings on regular headings, if not every paragraph, then close, then you have a synopsis of what's in the document. And more importantly, is if you have covered an issue more than once, by looking at the headings you've put on the paragraphs, you'll be able to tell very quickly. And in this way, really for me, always, the hardest part of structuring a large, complex document has been ordering my arguments in a clear and concise way. I generally wind up arguing the same thing 2 or 3 different times. By putting headings on all your paragraphs, you won't have that problem. That problem just take care of itself. And a lot of the things we talked about last week and we're talking about today, they're just some methods that if you use them, they will eliminate a lot of problems that we normally have when trying to construct a large document. They will just not occur. And starting at the end of your document, starting with the pattern jury charges and working backwards from there will eliminate a large number of problems we often have in creating large documents. And the other thing are headings. You will be surprised at how much headings will improve not only the style of your document, but the ease with which you can create one. And there's also citations. There's a tool in most every word processor for citations. And it's just in Word, when you if you put a statute in a document, and we have the rule, never make a proactive statement of law out of your own mouth. So always cite, if you're stating, the officer must do this, you always say, according to statute so-and-so or case law so-and-so, the officer must do this. But when you put in that citation, if you highlight it, and in Microsoft Word, if you'll go to, which one is it? I always have to look for it, references. In the top ribbon, click references. Right under that, you'll see table of contents. If you have used the styles menu to put headings on all of your sections, then you click the table of contents and you can tell Microsoft Word to put in a table of contents, and it'll create the whole table of contents for you automatically. You won't have to mess with it at all. And that's just by using the style sheet headings. If you put in citations, if you mark each citation when you open this section references, you go all the way to the right-hand side, and there's a box for citations. And in that one, you select whatever the citation is, and you click mark a citation, and it opens a box where you can tell it if it's a statute, case law, treatise, and there's several options. And then when you click off of it, it just goes away. But it puts code in the background that it can use later to create your table of authorities for you. And that will save you major work, especially if you're doing a Supreme Court. Lost my word. Hang on. We're about to go to break and my tongue got tangled. Randy Kelton, Rule of Law Radio. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio. Excuse me there. I think I swallowed a bug. Okay. there's a section on style I would like to go over here. I'm not sure how many of the listeners will find a great amount of value in it. For me, it's been tremendously important, but it's a little bit more sophisticated. And I got some feedback about presenting things that were not at an 8th grade level. Well, excuse me, I'm having a little voice issue. Okay, I think I got that bug out of there, out of my throat. Or maybe not. I wanted to talk about just, excuse me just a second. I'm not sure what this issue is, but I'm having a little bit of a voice issue today. I'll try to struggle through it. Okay, I wanted to talk about some underlying structures that, for the most part, if they're used well, the reader won't really notice them. Things like pacing, leading, pattern interruption. Pattern interruption is really the opposite of flow. But if we have time, we'll get to how you use an interruption intentionally to deepen the attention of the reader. I'll start out with pacing and leading. The whole structure we talked about in flow about telling your reader what you're going to tell them, and then tell them what you told them. The point, by doing that consistently, you pace and lead. You give the reader a direction for him to expect you to go in. You go in that direction and lead your reader along in a direction he expects to go, and then you extend on a regular basis from one point to the next. You pace what you've already stated, and then you lead to something else. On a more sophisticated level of pacing and leading, when you speak to the reader, you want to speak to the reader in terms that the reader will associate with. I was doing some research on some linguistic structures a couple of days ago, and I pulled up an article on a certain type of preposition use. It was a white paper by some professor. I read the first 3 sentences, and it was clear. No human being on the planet could make any sense of those 3 sentences. I don't know who he wrote them for, but he certainly did not write them for other human beings to read, because almost every word he used was a term of art, was a specific, I want to say industry specific, but it was a term specific to the study of that subject matter. And it had a special meaning in that subject matter and nowhere else. So someone trying to read this is going to have a dictionary with him, a dictionary specific to this area of study, and look up the meaning of every word he said to try to figure out what the heck he was talking about. Now, this is someone who's doing a PhD in English, and he writes in a way that no native speaker of English could understand. When we write to develop flow, we use terms and we use linguistic structures that a human being naturally understands. We talk about things in the person's environment that will make sense to them. Like if I wanted to pay someone about how someone looks, I would use structures things that everybody paid attention to. Someone once asked me to hypnotize them to help them lose weight. Well, I told them that I don't do normal hypnosis. I only do secret hypnosis. So you got to agree to let me hypnotize you without you knowing it. Well, she laughed and thought I was joking. And, I told her she had to agree to it. And she said, sure, go ahead. So I looked at her. I looked at her body conformation. And she was in her 50s or so. And I tried to get a good idea of what she looked like when she was in her 20s. And I told her a story about this person, and I described what I thought she looked like when she was in her 20s. And each time I would make a statement, I said this woman was a big old woman with big breasts and a big belly. Well, this particular woman happened to be barrel-chested. If you're barrel-chested, especially for a woman, it's a problem because your diaphragm is rounded and it pulls out your stomach. You never can get a flat stomach, no matter what you do. I have a niece that is barrel-chested. It drives her crazy. She can't get a flat stomach. And it was clear that this woman had a pronounced barrel chest. She always had somewhat of a stomach she couldn't get rid of no matter how skinny she got. And I know women pay attention to that, so I described what was in her environment that she would recognize and associate with. So I paced her. I paced what she looked like 20 years ago, and in each characteristic I referenced, she gave a slight nod. When you're writing for a reader to understand, you want the reader to read a portion and nod and agree, or fully recognize it. They can fully understand and recognize what you're saying. That's pacing. Once you put together a set of structures that an ordinary person will understand, then you can lead from those structures to some they may not necessarily associate with what you were just presenting. I'm listening to myself tell you this, and I'm confusing myself. I need to work up a better way to present pacing and leading. So I won't waste any more of your time with that for the moment. I was going to speak to two other primary structures that anyone who's studied poetry will understand. I am not by any means a poet, but in studying writing, it's one place you have to look. And everybody, even if you don't like poetry, you should study poetry. There are two primary things in poetry beyond rhyming sentences. It's meter and alliteration. Meter is an extremely powerful tool to speak to rhythms that go on essentially out of the direct awareness. I once wrote a letter to a sheriff that I really wanted to have effect. It was to the Tarrant County Sheriff. So I wrote out the whole letter, and at the time I was studying meter. Meter goes to the number of syllable sounds in a sentence or a stanza, like iambic pentameter. Iambic pentameter is all about meter. Iambic pentameter goes da 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 da. So you write a set of lines that the entire sentence has exactly that number of syllable sounds. And you can see with these short stanzas, they're noticeable. They ring in the mind, and the writing becomes kind of sing-song. But if you take a document, like in this case, I took the document and I counted all the syllable sounds in each sentence. And then I looked at it and developed a high average and a low average. High average was 15. Low average was it's time to go to break. I'll pick this up on the other side. Randy Kelton, move on.
Do you have trouble selling your ideas and winning people over to your point of view? I'm Dr. Catherine Albrecht, and if you'd like to speak more influentially, I've got an easy tip that can make you look and sound more persuasive right after this.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Negotiating. It's an art few of us ever master. If you have trouble convincing others to come around to your viewpoint, you may need to change the way you speak. Eric Barker, a blogger on human behavior, says one key to influencing others is consistency of tone. Stuttering, long pauses, and varying pitch in your voice do not inspire confidence. A consistently narrow tonal range, he says, conveys control and certainty. Whether giving a presentation or negotiating a salary increase with your boss, it can give you an edge. It signals focus and determination, qualities people associate with winners. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
You're listening to the Logos Radio Network at logosradionetwork.com. Yeah, I got a warrant. And I'm going to serve them to the head government, them. Prosecute them. Okay. All set. Citizens are ready. Well, Mr. Bush.
Okay, we are back. Randy Kelton, Rule of Law Radio. And I was talking about meter. I took a letter that I had written to a sheriff. I counted all the syllable sounds in each sentence. Did a high average and low average. The high average was 15, low average was 11. So then I went back and rewrote the letter so that the first sentence would have 15 syllable sounds in it. The second sentence would have 11, and so forth down the document. Meter, when done well, is so subtle that the conscious part of the mind of the reader will never pick it up. Conscious mind of the reader is paying attention to the details and the concepts, and they're trying to string all the concepts together. But the inner mind pays attention to rhythm and meter. That's why music is so compelling for human beings. The conscious mind listens to the lyrics. The inner mind, the peripheral awareness, pays attention to the meter or the beat. When you're reading a document and you read a sentence and it has a beat in it, da-da, 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 and you read the next one and it has a similar beat, maybe a little shorter and a little longer. Next sentence has the same as the first, and cycling that way, the inner mind will detect the beat and expect the sentence to end right on the beat. If it does end right on the beat, the reader will have the experience of rapport. Why it works that way, there's probably some folks that's got some real sophisticated explanations. But the point is, human beings are very good at detecting rhythm, and they detect rhythm not with the conscious aspect of the mind, but with another aspect. And when the writing creates an expectation of meter, and then the reader experiences that expectation, it causes an experience of rapport or connection with the writer. I don't expect you to do that. Meter is really hard to do, and it's time consuming, and no one would want to meter their whole document. But if you have an understanding of the concept of meter, that will tend to protect you from writing run-on sentences. It will protect you from writing sentences that are too short and sing-song. Once you kind of get a feel for it, you begin to notice the rhythm of the writing as well as the content, you'll produce a much more readable document. And another tool that's just one of these interesting little aspects of how human beings do what they do goes to alliteration. In poetry, for the most part, we rhyme. And rhyming is where you have similar consonant sounds at the end of a sentence or phrase. Alliteration is where you rhyme a consonant sound at the front of the word or the middle of a word. And instead of, I'm sorry, I stated rhyming wrong. Rhyming is we rhyme consonant sounds at the end of a word. In alliteration, we rhyme consonant sounds at the front or in the middle. Am I confusing everyone? I'm confusing myself. In rhyming, we always rhyme the end of the word, period. This is the first time I've tried to present this on the air, and I'm struggling with it. I hope to get better at it. Alliteration. You rhyme a syllable sound at the front or in the middle of a word instead of the end. I have some classic phrases that I tend to use in my documents. One of them is a carefully crafted criminal connivance. Now, that's very obvious alliteration, and it would be hard to miss. If anyone knows anything about alliteration, they'll pick that up immediately. But often we come across less obvious forms of alliteration. You can use syllable sounds at the front or middle of a sentence, and the reader will stitch those two together, and it adds to the rhythm of the reading. The mind is really good at detecting alliteration. And alliteration rings in the mind. If you look at advertising signs, you'll find that all over the place, where the words rhyme somewhere other than the end of the word. Anyway, just something to look for. And once you're aware that it exists, you don't have to really understand alliteration or meter. But once you're aware they exist, then when you read, you'll begin to notice them. And when you write in your own writing, you'll begin to notice where you can use it to increase the experience of the reading. So I'm going to get away from that, and I'll try to work up a better way of presenting this before I go to that part of this presentation again. A couple of things I do want to go to. I want to go to some things to avoid. Things to avoid when writing a document that you want people to understand. I had someone call me today and question about my using a rather sophisticated term when I'm talking about writing a document for eighth graders. Well, writing a document for eighth graders is not something simple. It's easy to write a document that's very complex. Humans think in complex structures. But if we write in complex structures, the reader's not going to have any idea what we're talking about. So we have to take our complex thinking structures and convert them into a presentation that an eighth grader could understand. That way, a very intelligent, very sophisticated person can read our document, read through it one time and understand it. Not get tripped up, not get lost, but flow through the document. And some things that really get in the way of flow. First one are acronyms. FDCPA. Now, Fair Debt Collections Practices Act. I know what that means. But if I see that in the middle of a document, I always have to stop and make sure that I'm seeing Fair Debt Collection Practices Act. I got to make sure all of those letters are in the right order to make sure I'm not mixing it up with Fair Credit Reporting Act or some other possible acronym that could be there. Always, acronyms cause pattern interruption. They knock you right out of flow. You're moving along an argument and you're collecting up the information, and all of a sudden you hit this speed bump and you stumble over this acronym. You got to check and make sure it's what you thought what you expect it to be. If you put in Fair Debt Collections Practices Act, the reader will look at that and they won't read, after the first time they've read it, they won't read Fair Debt Collection Practices Act. They will look at that whole name and recognize it like you recognize a Chevrolet. Bam, in an instant, they recognize the whole thing. Yes, it uses more words than are absolutely necessary. And generally in writing, they tell you if a word's not working, take it out. Well, when you use words in a proper noun or title of this nature, those words are working. They're working to make the reading much more fluid and simple. It looks like you're adding more words, but the mind will jump right over them and never stumble out of flow. So avoid acronyms. We're about to go to break again. When we come back on the other side, we're going to talk about avoiding pronouns and why pronouns are such a problem. And how I'm alliterating pronouns. Randy Kelton, Rule of Law Radio, or call in number 512-646-1984. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Rule of Law Radio. And I'm going to present some problems peculiar to pronouns. I just couldn't help myself. Pronouns. Pronouns go to referential index. The human beings are incredibly sophisticated mammals. We're able to do some incredibly sophisticated things mentally. I really need a better way to phrase that. But the way human beings are able to become so sophisticated is that we learn very simple and simplistic ideas and concepts, and we cluster those together into various contexts. Hunting, cooking, gathering, all the things we learn about hunting, we put together into one context so that when we go hunting and we look in our mind for how to hunt, it first goes to the hunting context. And then we see tracks that indicate a certain kind of creature. So we go to how to hunt this particular creature. And we break down the plethora of possibilities into finer and finer distinctions. And we do this with referential index. That's one way of stating. We do it with context. We have a way of mining down through these massive amounts of information we have from the general to the more specific. When you're trying to present a concept to someone, you must always give them referential index. You have to be very careful to let them know the context in which you need to address this particular issue. If you're not careful in framing the context, you may get back to this issue we've spoke to earlier of complex equivalence, where you say something and you mean one thing by it, but the reader has a different model of the world. We each have our own internal model of the world we live in, and they all look alike, but none of them are the same. So you use a string of verbiage and it means something to you. It could mean something totally different to the other person. Or you could use a word or a statement and you know exactly what you mean by it, but your reader doesn't have a clue. You always want to avoid creating a question in the mind of your reader, unless you create that question on purpose and immediately answer the question. If you create a question in the mind of your reader and you don't immediately answer it, or you haven't set up an expectation that it will be answered, you've lost your reader. I mean, who here hasn't been in a seminar and had the speaker say something and you think, what? What did he mean by that? And the speaker just goes on at 200 to 300 words a minute, just moving right down his presentation, and he doesn't know he lost you. And by the time you find connection, by the time you locate referential index so that you can make sense of what he said, he's already gone away from you. Now you got to struggle to try to catch up. If you're writing a document that you want someone to understand, if you're writing a document for an 8th grade reader, make sure you always give that reader referential index. And probably next to acronyms, the biggest offender as to referential index are pronouns. He, she, her, they, it. You know what you mean by it, and it may or may not be the same thing your reader attaches to it. You know what the referential index is. Lawyers, it is their job. Opposing counsel, it is their job to misconstrue your document any way they can. So when you're writing, especially a legal document, avoid pronouns like the plague. Use proper names. The only time I'll use a pronoun is if I've already used the proper name in the sentence, or maybe in the sentence just above, and the reference is so absolutely crystal clear, no reasonable person could construe a reference other than the one I intended. This is one of the biggest and one of the most subtle offenders to the concept of flow. You use this, my wife is always doing this to me, it frustrates her and it frustrates me. Did you see that? Huh? What? Which? I have no idea what she's talking about, but she knows exactly what she's referring to. And then when I ask her for referential index, I have struggled with doing it in a way that doesn't annoy her, but yeah, you know how husbands and wives are. It always annoys her. So avoid pronouns. And another thing that will protect you from run-on sentences is to avoid the overuse of conjunctions. Often, when we're deep in a subject matter and we're trying to explain a complex idea, we don't want to lose our reader. So we're concerned that if we put in a period is a place where the reader mentally stops. It finishes a statement. But we're tying all these pieces together. So we don't want to stop. We want to make sure that they tie all these pieces together, so we put in an and instead of a period. And then we wind up with a sentence that's a whole paragraph long. You want to see how hard that is to read? Go to Texas Code of Criminal Procedure 15.17 and try to read that page-long paragraph and make sense of it. No human being on planet Earth can read that paragraph and make sense of it. In order to understand what was in that paragraph, I had to outline it. First, I put a carriage return at every period in the whole thing and made it separate sentences. And then I outlined those sentences by subject matter reference. And it took about an hour. But then you could read it and understand it because it was broken up where human beings could put it together. Avoid conjunctions. I'm not saying don't use conjunctions, but try not to use more than one conjunction in a sentence. If you have more than one conjunction, you want to separate sections with commas and be sparing with those. Short sentences are wonderful. And when you have a series of short sentences following one another, you don't lose your reader. What you do is you allow the reader to kind of take a mental breath. You give him a piece of information, you put a period there, and now he can take that piece of information, and he's got a period. It gives him a second to attach referential index to it. And then he reads the next sentence, and he gets a second to attach this sentence to the one in front of it. If you connect these with conjunctions, it tends to move the argument or the explanation too quickly, and people don't have time to stitch these together as effectively as they would if you put periods in place. Okay, enough said about that. Conjunction, mixing elements. Mixing elements for unsophisticated writers, pro se's writing legal documents. You may be a professional writer, but if you're not a legal professional, then when you start writing legal documents, you're not a sophisticated writer because legal documents are a different kind of writing. And one of the primary things that we mess up in legal writing, I apologize for that term, I couldn't find one that sounded better at the moment, but one of the primary problems we have in mixing up elements, when we start arguing an issue, we start explaining an issue, we'll get halfway through the explanation and then an important associated point comes to mind. And we want to make sure that the listener understands this point. So we add that point in there. And then we add that point, and that leads to another one. We had another point in it. Before we know it, we don't know where we're at. We wind up moving from one element to another and not realizing we're doing it. We argue two or three things at one time. Exercise mental discipline and only argue one element at a time. And this is primarily the reason that I suggest that you put a heading on every paragraph. Headings on every paragraph will help you to discipline yourself when you're writing so that you stay on a single point. At the end of a paragraph, you can address those issues you would have put in for clarity. But if you try to do it all at once, you mix the elements together, it makes absolutely no sense to your reader. Okay, we have the phone lines on. I apologize, but I didn't realize why I wasn't getting any callers, and it's because I didn't have the phone lines turned on. We have them turned on. We'll try to keep them on for the rest of the night. This is Randy Kelton, Rule of Law Radio, and we still have our fundraiser going on, and it's not going as well as we had really hoped. We are kind of struggling here to keep this network on the air. So during this long break, you might check out Logos Radio Network and help us support this station. We'll be right back.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly.
Okay, we are back. Randy Kelton, Root of Law Radio. And when I'm going through these different aspects of writing, I'm not doing this so that everybody will fully understand everything I'm talking about. I'm going through these primarily just so that you can have some familiarity with the concepts and with the structures of these issues, so that when you come across something that doesn't look right, there's a good chance that you'll begin to recognize that this fits into one of these categories. And once you can put a label on what you see, it makes it a lot easier to quickly understand. I'm trying to give you a tool for referential index to linguistic structures. I hope that makes sense. And please excuse me, this is my first time trying to present these. These are structures that I've worked with for a long time, but I've never tried to present them before. And I'm hoping to be able to get them out so we can get some pro se writers out there that begin to produce better documents that are more effectively structured. Okay, enough with mixing elements. Emphasis. Common problem with pro se writers. Very big problem in the legal reform movement is you see all of these documents these guys are producing, and they've got capitalized words or phrases. They've got, it's the biggest, the worst abuse is bold print. We set sentences or portions of sentences out in bold print because we want to make sure that the reader picks up on those. Well, it's a misconception of how that works. If I'm looking for a phrase that I put in a document and I don't have it highlighted in some way, either bold print or italics or underlined or something, then I have to dig through the document to find it. And I tend to get this idea that since I'm having trouble finding what I know is in there, other readers won't see it at all, even when they get to it in the course of reading, and that's not the case. What happens when I'm reading someone else's document and I come across a section that's highlighted, that always trips me. And I'm moving through the flow of the argument, and all of a sudden something stands out here, and I have to stop and figure out why I did that. Always bumps me out of flow. If your idea or your argument is not standing out in the mind of your reader, better to reconstruct the argument rather than do something to artificially highlight it. And if you have a sophisticated reader, he's going to be insulted by it. Especially if it's a judge and you've highlighted something for the judge, he is not going to be happy. Do you really think I am so stupid that I would miss that point? So you have to highlight it or put it in all caps to make sure this moron here reading it gets it. Avoid emphasis, artificial emphasis at all costs. Now, linguistic emphasis, that's a different thing. Write your prose so that it provides the emphasis you need, and avoid these artificial external pointers for your reader. Enough said on that one. Now we're getting to some structures that I'm not sure where to put them. I'm not sure if I should put these in a section of things you should avoid or things you should use in order to be artfully vague. I'll start out with the complex equivalence, and we've talked about complex equivalences before. And a complex equivalent is simply where I use a term and I have a meaning for it. And the meaning you have for that term may or may not be the same. This can be especially problematic in legal writing because in court they don't speak English. Yeah, I know it sounds like they speak English. They use words that a natural speaker of the language recognize, they've heard before, is very familiar to them. And that has a tendency to lull the listener into the misconception that the terms they're hearing in court are the same terms they hear out on the street. Not so. For the most part, a large portion of the terms used in court are terms of art. In that, in the context in which they use, they are used, they have a special meaning. One of the most obvious and common that everybody will recognize is person. Out here in the civil world, I'm a person. You're a person. We don't think of the car as a person or that company across the street as a person. I'm a person. We use the term person as a living, breathing human being. That's not what it means in law. In law, it can mean a living, breathing human being, but it also can mean a legal fiction. A legal fiction, that's a company, corporation, trust, LLC. These are legal fictions. These are artificial entities created under law. But a corporation in its own right has certain rights. It essentially has the rights that a person would have. And in court, when they say person, it doesn't necessarily restrict itself to a living, breathing human being. But if you're pro se and you're not aware of that, you can think you understand what is being talked about when you don't have a clue. You know, Deborah warns us regularly about how we have to be extremely careful so as not to enter into a contractual agreement with a governing agency. And that's because law is different than ordinary civil intercourse. If you and I out here in the real world are going to enter into an agreement with one another, we tend to specify the agreement. We tend not to enter into a binding agreement with one another by acquiescence or by taking an action that would be taken in furtherance of the agreement. Sometimes we take actions just because we're polite and we're trying to get along. But in law, if the FCC sends you a letter telling you that you're in violation of their statutory governing rules, and you respond within the scope of those rules, you have acquiesced to the governance of those rules. You may not know that. So they have, in sending you this letter, they have failed to fully explain what the letter meant. So you had one idea, you thought it was just a letter, them trying to let you know that they felt you were in variance with the statutory structures. What it really was an opportunity for you to agree to participate in their statutory structures. This goes to complex equivalence. We don't need you to understand complex equivalence. Not completely, just to be aware that when you're reading a document, look closely at the terms, especially a legal document, and make sure that the term means what you think it does. And often you can tell that from the context you find it in. You see a term and something tells you, wait a minute. This may not be what I'm thinking it is. And it's perfectly all right in the legal context to request that another party define the term they're using. If you're in a traffic court and a police officer states that he observed the defendant driving a motor vehicle, objection. Please define driving. I have a meaning for driving. I'm sure this police officer has a meaning for driving, and there's a very good chance they are not the same. And if you listen to Eddie's show, you know exactly what I'm going to. We're speaking to the difference between driving an automobile and operating a conveyance or traveling in a conveyance. Driving an automobile are specific terms that have a specific legal meaning that if you agree that you were driving an automobile, you agree that you fall under the commercial nexus. So try to be very careful in accepting the meanings of terms. If you are not absolutely sure what something means, ask. If you're reading a legal document that you received from another party you can write a separate motion requesting clarification. Every term you're not certain of, ask the other side to clarify. Tell me what meaning you have for that word in this context. And you will be surprised at how different the meanings you get back are from the meanings you thought were attached to it. Okay, enough on complex equivalence. You don't have to understand it. Just when you see it, once you understand and there is this kind of structure, you'll begin to notice it. I'm just trying to heighten your sensitivity to these kind of things. And we're going to another break. When we come back on the other side, I'm going to go to lack of specification. These are one of the tools that I'm not sure where to put it. Do I put it on the side of things to avoid because it tends to leave out information? Or do I put it in the section on artful vagueness, which we'll talk to later, which is a method for creating internal rapport? Hang on. I'll try to make all of this make sense when we come back on the other side. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. Give us a call. We'll be taking your calls all night. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're getting to a portion that, frankly, I find very interesting, very powerful, but it is a bit more complex. So don't try to there's no need to try to really understand all of this. But I want to be able to give you some familiarity that these kinds of things exist so that you're reading something and this still small voice in the back of your mind says, oh, wait a minute, hold on, something's wrong with this. Something's going on here, and you're not sure what it is. This gives you some tools to help you sort of pigeonhole what's going on. For the most part, that's what this entire presentation is about, is just to give you some referential index for some sophisticated patterns that the bad guys use against you all the time, and for the most part, you have no clue. And we're going to start with unspecified comparisons. Okay. With unspecified comparisons, people will use words to imply something, and they'll state something that contains an unstated presupposition, and rely on the mind of the reader or the listener to fill in the empty spaces, to find the presupposition or to fill in the missing information. We have a need to find referential index, to connect pieces together. So when someone leaves a portion out, when they use a term that does a comparison, I make this soap, and this soap it's just better. Well, better than what? Well, if I keep talking, if I keep moving along, then you have to reference something to better. And you'll go in your own mind and imagine what I mean by better, and you'll attach what you believe I mean by better to my term without realizing that I didn't tell you that. And this can be, on the one hand, very misleading, but on the other hand, it can be extremely hypnotic. It can suck you in without you realizing it. So when people start using general terms that, like this one, every day in every way you are getting better and better. Better and better than what? There's a lot of them. I need to deliver this more time so I get better at these examples. But enough on unspecified comparisons. If someone is not very specific on what they're comparing, on what terms you mean when they're referencing something else or comparing what they're doing to someone else, you need to ask for it. Unspecified objects. These are words that sound good but are actually quite vague. Words such as learnings, outcomes, resources, findings, consideration, they can be used to ground almost anything. By using inclusive words, the reader finds closure from their own internal resources. So I leave something out. In order to make sense out of what I'm saying, you have to fill in the empty spaces. Now, we can use that, and I'll speak to that when we get to artful vagueness. But if you're reading a legal document trying to make sense of it, oftentimes the lawyer will pretty well understand how the ordinary person, and for the lawyer, for the most part, they're speaking to a jury, how they will fill in these empty spaces. Whether they're true or not, it's relatively easy if you do this artfully to get someone to come to a conclusion that may or may not be true. But you can't be pinned down on it because you didn't specifically state that conclusion. You simply subtly led the other person to the conclusion by using unspecified objects or unspecified verbs. I won't spend much more time, and we won't go to implied cause and effect. Everybody's dealt with that at one time or another. And I'll present this again in another month or two and try to present it a little more artfully than I am this time. And lost performatives, we won't get to lost performatives this time. We'll do that next time. I'll spend a little more time. All I'll do for this presentation, I'll talk about artful vagueness because it has some really interesting structures, and then we'll go to callers. And our call lines are open, 512-646-1984. Okay, artful vagueness. One of my favorite tools to use to be artfully vague is what I call a conversational ellipsis. A conversational ellipsis is where you use a phrase that's very common, and you just use part of the phrase and leave a portion of it out. There are, when we're speaking, we speak at 200 to 300 words a minute. But when we're reading, and when we're speaking, because we're speaking this quickly, we have to give people directing terms. We have to give them words like that. That is a real common word that we need to use so that people will understand where we're going. For the most part, if you take that word out, the mind will put it right back. Won't even notice it wasn't there. And when I'm writing a document that I want to create rapport in the mind of my reader, I will look for phrases or portions of phrases that are so common in the speech patterns that if you take it out, the reader won't even notice. The mind will just put it right back. Someone once sent me an email and asked me to count the number of times if occurred in the email. I never did get it right. Even after they explained it, I went back and reread it and still didn't get all of them. It's one of those, if winds up in phrases in a way that is so generic and common to the linguistic patterns that when they leave it out, we don't even notice it's not there. We just put it right back. That's conversational ellipsis. Very powerful for creating rapport. And extended quotations. I can pretty well plant most anything in your mind without objection if I attribute it to someone else. I told a sheriff's deputy that I happen to know in Wise County. I met him. And he said, "How's it going, Mr. Skelton?" I said, "It's going good. But you know, John, somebody told me the other day that you had gotten fat, old, and ugly." "Who told you that?" "I don't remember who told me that, but they told me you got fat and old and ugly." "But John, you didn't get fat." And he stood there looking at me. He really wanted to get mad at me, but he didn't know how he could because I didn't say that. Somebody else said that. If you want to tell someone and something that you don't want them to consciously analyze, attribute to quotations by somebody else. And for the most part, we use an unspecified quotation. So we don't tell them who said it. We just tell them it has been said that. Or I knew this guy once and this is what he believed. You can get people to accept things they otherwise wouldn't just by quoting someone else. And okay, I am out of time, and I'm kind of struggling with this presentation. I hope the next time I do this, I will be more comfortable and have better examples of what I'm doing, and maybe I won't confuse everybody and put the rest of them to sleep. Chris, we'll pick you up when we come back on the other side. Randy Kelton, Rule of Law Radio. We'll be right back.
Is internet addiction for real? New research suggests it is. In fact, scientists may have isolated a gene responsible for compulsive web use. I'm Dr. Catherine Albrecht, back with details on why the internet can be addictive after this.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Do you know somebody who's online nonstop, like a child, a friend, or maybe even you? A new study suggests this compulsive behavior might actually be a sign of internet addiction, a condition that may be exacerbated by a single gene. Researchers studied problem web users and matched their DNA samples with people in a control group. They found a variation in a gene that activates the brain's reward system. That's the same receptor that puts out feel-good chemicals like dopamine when we eat, sleep, or smoke. The genetic variant was more prevalent in the internet-obsessed group, particularly among women. But don't just blame your genes. There is some willpower involved, too. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Actually be kidding about chemtrails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio, and I will stop putting everybody to sleep for now. And we're going to go to Chris in Pennsylvania. But before we do, just one note about what I'm doing here. What I'm going through over the air is an ebook that I'm constructing. And it's one thing to think this out in your mind, but it's quite a bit different when you actually speak it, and especially when you're speaking it to an audience that you can't see. So I have to struggle to find a way to present this so that you will understand what I'm talking about when I can't look at you and tell when I'm confusing you. So it's a very good mental exercise. And if I sounded like I was struggling, it's because I absolutely was struggling. But I'll get better at this, and I will combine it all together into an ebook that we'll make available on the network. Okay, Chris in Pennsylvania. Do I have you thoroughly confused?
No, you're not at all. Since we've had a discussion in the past year, I've read several of the books you recommended on the NLP process, and it makes very good sense. I love the Artful Vagueness, and that was kind of what I wanted to talk to you about.
Okay, I love Artful Vagueness. It's on the one hand, it's very sophisticated. But on the other, right, it's relatively simple to use.
Yeah, I was looking at a couple of case law things that just happened over the course of the last week, and it's just interesting that you brought that up because the topic that I was hoping would fall in conjunction with that is the Supreme Court case that just came through out of California.
Yavanova. I'm saying it wrong. Jeff Sedgwick needs to call in and tell us how to pronounce that, because she was a member of Jeff Sedgwick's group. This is Jeff's stuff. Mm-hmm. The Y is not pronounced. It's Inova. It starts with an N.
Yeah. I was anyway, you'd help me with it because I wasn't going to say it right either. But that court case, I mean, everything that was discussed about the rights of the mortgage for the borrower, and your artful vagueness, I was wondering if maybe the contra preferentum ambiguity of things that are written in your mortgage, for example, where it states that everybody's mortgage or deed tells you that the borrower is lawfully has the right to warrants and will defend generally the title and property against all claims and demands subject to the encumbrance of the record. That's something when you go to court with these cases, if all case law is ruling or the bank is making the statement that you are not party to this transaction and can't fight the fact that your mortgage may be assigned fraudulently, how do you get past that to have actual adjudication?
Yeah, you have a duty to protect this against a false claim.
Right.
And now they're saying you can't protect it against a false claim. But in this case, the rulings are actually well structured. I was talking to a friend of mine in Austin today about this issue, and he sent me a case where he felt like the courts threw out all of our arguments. But when we looked at the case, the courts were saying that you can't challenge a contract between parties to which you are not involved. And yeah, that's true. And the problem that we've had is not that we're trying to challenge a contract to which we're not privy. What we're trying to do is claim that the contract itself is void on its face. And this is exactly what Jeff Sedgwick talks about all the time, the difference between void and voidable.
Right.
If a contract is voidable, say you and I enter into a contract and you don't properly affirm the contract. The contract, I could say, this thing's void. You didn't affirm it. But if I'm the one that wants you to enter into the contract, I'm not going to raise that issue. If I don't raise the issue, it doesn't become an issue. The contract is voidable, but it's only voidable by one of the parties. So we have a transfer or an assignment here where the assignment was not filed in a time limit that it was supposed to be filed in. So it affects the two parties, the assignee and the assignor. It doesn't really affect the borrower. Now, if one of those parties wants to raise an objection to an impropriety in the contract, they certainly can and could probably render it void. But if they don't want to, they don't care about the problem, and they're willing to participate in the contract anyway, what business is that of mine? However, if they have filed in the public record a document that is void on its face, or if they attempt to exercise a claim based on a document that is void on its face, for instance, if it has an affirmation that is fraudulent, if it is affirmed by someone who has no power of attorney to affirm the document, then the document is forged, and a forged document is void as a matter of law. I just read a case where this guy Bly, one of the most well-known robo-signers next to Linda Green, had signed this document. And Bly has testified in the court that people were putting his names on documents he didn't know anything about. So they argued that the foreclosure was improper because this Bly had robo-signed this document, and the court ruled against him, and rightfully so. And in the dissenting opinion by one of the three appeals court judges, he indicated that the document was void on its face. But the litigant didn't argue that it was void on its face. He merely argued that it was robo-signed. Had he argued that under, I forget the exact statute, but we have a statute that says that a void document is of no force in effect. Had he argued that in his pleadings, he would have won. But he didn't make the right argument. He had to argue that it is void on its face, and then the court could rule in his favor. This is essentially what that case goes to. They argued it correctly. and they got a ruling in their favor. What it really says is, and Inova they picked it up to handle a difference between the circuits. The Southern Circuit said that you don't have standing to challenge an assignment. That was the Jenkins case. Glaske said you do have standing to challenge an assignment. So the Supreme picked up Inova, because that's exactly what it went to, in order to settle this difference between the circuits. And they settled it big time, and we'll pick that up when we come back on the other side. And I know I hijacked you, Chris. I will get back to you, I promise. But this is an interesting case. Randy Kelton, Rule of Law Radio. I call in number 512-646-1984. We'll be right back.
Easy.
Well, you know, karma's lurking around the corner. You better watch every step you take. And good will follow you. Yeah, but Jerry, sing reality.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're talking to Chris in Pennsylvania. And Chris, before I hijacked you, I probably should have backed up and asked, what did you really want to address this issue, or were you going somewhere else?
No, I really wanted to address this issue. I wanted to address the issue of challenging the mortgage assignment, because that's kind of where my issue stands with my assignment and the things that were written on it. In order to get it void on its face as a forgery, which I hear so much talk about, and I'm looking at my document, and I'm just trying to figure out how, on the document of the assignment recorded in the Recorder of Deeds office, it states that it says executed by my wife to MERS, which is just a fallacy of anything, because my wife can't execute the mortgage to MERS. Only the bank could do that.
Is MERS named on the note?
No.
Is MERS named in the security instrument?
Yes.
Okay. If yours is a Fannie Mae, Freddie Mac uniform instrument, I'm not sure what it looks like in Pennsylvania, but if it's a standard deed of trust, the deed of trust doesn't convey anything to MERS, because where MERS is mentioned is in the definition section, and that's not a part of the contract. It names the parties and defines some terms, but it's not a part of the contract. The only part of the contract that references MERS at all will be the second paragraph of the contract. You have the first paragraph that transfers the property to the trustee. And then the second paragraph addresses any additions to the property beyond what was initially part of the collateral. And it essentially says, as you add anything to this property, what you add becomes a part of the collateral. And right in the middle of that paragraph, they put this sentence in there that says you understand that MERS is not the beneficiary, but merely holds legal title. That's the only reference to MERS. Now, it doesn't state that you transferred legal title to MERS. It's one of those artfully vague terms. What does that mean? Right. MERS holds legal title. I thought the trustee held legal title.
Right. Well, that's the interesting part when you read into that. The artful vagueness of that is, if the bank doesn't hold legal title and all beneficial interest was given to MERS, then the bank is no longer an entity in the transaction.
Yeah, and if that is the case, then what you have is not a deed of trust. What you have is a mortgage.
Right.
Okay. Yeah. And for those who don't understand the distinction there, in a judicial state, in order for the lender to give you the warranty deed to this property on a promise that you will pay him in the future, he wants you to give him a promise or give him a privilege. Normally, if I loan borrow you money, or loan you money, and you don't pay it back, and we have a contract where you agree to pay it back, I can sue you. And then I can get a judgment against you. And then I can use that judgment to get a claim against your property so we can liquidate your property to pay off my claim. Well, the banks don't want to go through that. So they say, okay, I'll loan you this money, but you have to give me a claim against your property. You have to grant me the privilege of a claim against your property so that I don't have to sue you first, get a judgment against you, and then file against your property. If I have a claim against your property, now you can't sell that property because it would defeat my claim. So I can protect my collateral. That's a mortgage. You technically, in a mortgage, you transfer legal title to the property to the mortgagee. Mortgagee. So you transfer legal title to them. We're in Texas and we have a deed of trust. And it's not property code, it's I forget the code. There's another code, torts and remedies. Torts and remedies specifically forbids a lender from requiring the borrower to transfer the property to the lender. There's a good chance you've got a similar statute in Pennsylvania. Business and Commerce Code. Look in the Business and Commerce section of your code and see if there's a place there that forbids a lender from requiring the borrower to transfer title to the property to the borrower. So if this is supposed to be a deed of trust, then legal title should be transferred to the trustee, the whole point of a trust. But if you transferred it to the borrower, not only in Texas would it be in direct violation of law, but it's not a deed of trust anymore. Now it's a mortgage. Okay, did that make sense?
Mm-hmm.
And if it's a mortgage with a extra privilege. The difference between a mortgage and a deed of trust is, in a deed of trust, not only do you give them a claim against the property, you give them a confessed judgment. You confess that if there's a default, I grant you a judgment. But, okay, it sounds like with MERS, back to your original issue, your wife can't convey to MERS. Well, if you have that standard contract, there's nothing in there that grants anything to MERS.
Not from my wife.
Well, not from anybody. The contract doesn't say that, you're the grantor. It doesn't say, I grant legal title to MERS. It doesn't say that anywhere.
Right.
It says you grant the property to a trustee, not to MERS. And then you have this vague statement in the middle of the paragraph that goes to added collateral, and they stuck MERS in the middle of that. So what does that mean? I don't see anything in there that says that MERS was granted anything. MERS can be an agent for the lender, but that doesn't require a grant by the borrower.
No.
Anyway, what is your take?
Well, my confusion lies within interest in the property. Who's conveying interest to whom? It appears as though the bank and MERS are solely the two parties in question there. The bank is giving MERS this ability, which it's really never assigning it to them, since the bank nor MERS signed.
Okay, that raises a question. The bank is giving MERS. Where in that document? Okay, where did they give MERS this? Are you saying that in the deed of trust the bank is doing this, or somewhere else?
That's what it's implying, or appears to imply.
But then again, the problem is the bank didn't sign that thing.
No.
They didn't affirm it, so it can't be construed that the borrower granted anything in the deed of trust. Deed of trust was a grant by the lender didn't grant anything. The grant in the deed of trust was by the borrower to the lender. the borrower didn't grant anybody anything in there. If they did, they would have had to sign it. And there's no verbiage in there saying that the borrower grants anything. There's a definition of MERS as an agent, but MERS is not made an agent by this document. Because I can't assign an agent for the borrower. For the lender.
Right.
Yeah, I'm going to say, okay, look. You got MERS over here as your agent. I don't like him. Those guys are scoundrels. I want to get rid of MERS as your agent, and I want to appoint my brother-in-law. How's that going to work?
Right. But it's a matter of interest as well. It's a matter of who's giving whom an interest in what, and what MERS by MERS members' definition say MERS can and cannot do.
Yeah, and the Fannie Mae Freddie Mac uniform instrument with MERS. I think the guy who wrote that was high on coke. It doesn't make sense. If you read the contract carefully, it doesn't make any sense. Hang on. I like the subject because I do like to tear that particular contract apart. I don't see how it can be enforced the way it's written. This is Randy Kelton, Wheelball Radio. Our call-in number, 512-646-1984. This is the top of the hour break, so it's a good time to go to Logos Radio Network. We've still got the gun giveaway going on, and so far we haven't got enough donations to even cover the price of the gun, so we need some help here. We'll be right back.